हाँ प्रदीप सर।
Yes, I am there.
हाँ नमस्कार सर।
नमस्कार जी जी नमस्कार।
So
नमस्कार प्रदीप जी।
जी जी नमस्कार।
I welcome all present here to this seminar, Scope of Mediation in Criminal Cases. Today we have with us Shri Pradeep Rai ji, Senior Advocate, Supreme Court of India and Vice President, Supreme Court Bar Association. I would request our Professor in charge, Law Center 2, Professor Dr. Mahavir Singh ji, to welcome our esteemed guest and to formally declare open this seminar. Professor Dr. Mahavir Singh ji.
Thank you, thank you. I declare to formally to open the seminar and thank you, Saurabh Rana ji, honorable distinguished guests, Pradeep Rai ji, Senior Advocate, Supreme Court, esteemed colleagues and dear students present here for this webinar. Very, very good evening to you all. I am sure that all of you know to the fact that gold has been the standard of exemplary purity and excellence since time immemorial. I am very happy to be the part of milestone of Law Center 2 for the celebration of its Golden Jubilee. Law Center 2 is celebrating its Golden Jubilee year 2021 to 22. We have already successfully organized number of programs, events and activities, and we are on our way to create a roadmap for the future generation and continue of celebrating 50th Golden Jubilee year of Law Center 2. Today, we are adding one more event in our Golden Jubilee celebration. Law Center 2 has a long, proud and distinctive history. It is one of the distinct center of the Faculty of Law, University of Delhi. Law Center 2 was founded in the year of 1971 at the premises of ARSD College, Dholakwa, New Delhi, to provide a quality education while offering full-time LLB program. Today, Law Center 2 is a Golden Jubilee Center, continues to be a progressive center and made a strategic commitment to the higher quality of teaching and research. It is a premier institution and is known for its qualitative teaching, research and other co-curricular and extracurricular activities. The center is a hub of research and learning for law students. To promote students' activities at the center, a number of committees have been constituted like moot court committee, debate and seminar committee, journal committee, legal aid committee, placement committee and alumni committee. Center had the privilege of being headed by the top law scholars of India such as Professor Upendra Bakshi, Padam Shri Awardee, a well-known jurist and former Vice Chancellor of University of Delhi, Tahir Mahmood, Professor Tahir Mahmood, who subsequently became a chairperson Minority Commission, Professor A.K. Cole, who was elevated as Vice Chancellor NLU Jodhpur and NLU Ranchi, Professor Gurdeep Singh Bahari, who became a Vice Chancellor NLU Lucknow, Professor B.T. Cole served as a chairperson Delhi Judicial Academy. Professor Poonam Saxena is presently Vice Chancellor NLU Jodhpur. Law Center 2 has the privilege of having alumni from all walks of life. As Law Center 2 is celebrating 50 years of teaching, the center has grown exponentially in the footprint, academic offerings, and student body. Today, number of alumni of centers are contributing in the future of India. Alumni included senior bureaucrats, police officers, revenue officers, doctors, engineers, chartered accountants, company secretaries, politicians, etc. Some of the alumni includes His Excellency Honorable Governor of Arunachal Pradesh, Brigadier Sri B.D. Mishra ji, Sri K.J. Alphonse, Member Rajya Sabha, Ex-Minister of State for Tourism, Justice B.D. Ahmed, Justice Kailash Gambhir, Justice S.N. Dhingra, Justice Rajiv Sankadar, Justice V.K. Rao, Mr. M. Damodaran, Ex-Chairman of SEBI, Mr. G.D. Gaya, Mr. Manoj Kumar Sinha ji, Professor Manoj Kumar Sinha ji, Director, Indian Law Institute, New Delhi. Among many more legal luminaries, Law Center 2 has been publishing its two journals named National Capital Law Journal and Delhi Journal of Contemporary Law, publishing quality research papers in the field of law and contemporary issues. I feel proud to be currently associated with Law Center 2. My dear students, colleagues, non-teaching staff, everyone associated with Law Center 2, we have crossed the zigzag path of thousands turmoil and tenacities, and today it is a time to celebrate, to introspect, and to consolidate, and to plan for Law Center 2 future. Today, we have event on scope of mediation in criminal cases. And today, we are having with us Mr. PRADEEP Rai, Senior Advocate, Supreme Court of India. He did his LLB from Banaras Hindu University, LLD Honorary from Invertees University, Bareilly, Uttar Pradesh. Mr. PRADEEP Rai ji is a Senior Advocate and Vice President of Supreme Court Bar Association. In the year of 2015, designated as Senior Advocate, Mr. Rai has over 2 decades of standing at the bar in the Supreme Court of India, various high courts, commissions, regulatory bodies, and tribunal. He has experience in litigation across a wide spectrum of civil, criminal, revenue, and constitutional issues. Mr. Rai represents the Union of India along with many states, including Uttar Pradesh, Uttarakhand, Bihar, and Andhra Pradesh. Mr. Rai is also the chairman of India Legal Aid Center and the chairman of India Legal Research Foundation. He was the former vice chairman of National Anti-Doping Agency, which is the premier organization under Ministry of Youth and Affairs and Sports. Mr. Rai has a deep-seated passion for access to justice. He has closely worked with former Chief Justice Honorable Mr. Justice M.N. Venkatachalaya and late Honorable Mr. Justice J.S. Verma. I extend my warm welcome to you, sir. It's indeed a proud moment for us to have with you, with us today, and I again and again, warmly welcome you, sir. And that here our students, teachers are eagerly waiting to listen to you. So that's why I request Rana ji Now over to Mr. Saurabh Rana. Thank you.
Thank you, sir. And before I invite our distinguished speaker today, I would briefly introduce the topic. Mediation, as we know, is one of the mode of ADR, wherein the matter is resolved out of court with a systematic facilitation by a mediator. Mediator is a third neutral party which, as per the set structured arrangement, provides an impartial and free environment to the two warring factions so that they may have meaningful dialogue and thereby the dispute may be resolved. Or at least some such questions are answered, which during the traditional adversarial trial would never ever surface, and that would never let the two parties to bury their hatchets against each other. In this context, if we look at CPC, we find that Section 89, Order 10 CPC, the initiation for ADR would come from the judiciary itself. In fact, if one ever happens to attend the refresher courses organized by Honorable High Courts for their judicial officers, the emphasis laid upon sending civil cases for one or the other mode of ADR would clearly be appreciated. But if you look at the criminal side, and when I say criminal side, I would restrain myself to CRPC and IPC. In CRPC, which is the general procedure provided for criminal cases, no such provision like those in CPC is to be found. Instead, in this context, Section 320 CRPC, which provides certain offenses compoundable or compromisable, is put to use for getting an out-of-court settlement in criminal cases. But because a clear legislative mandate in the form of express provisions like CPC for sending the case to mediation and for other modes of ADR is absent in CRPC, I have seen the lawyers not very forthcoming on the idea of mediation in criminal cases, and also the judicial officers hesitating in sending criminal cases for me. Just our distinguished speaker today to throw some light on this practical aspect in criminal trials. Also, I would say that it is only around 50 sections in IPC which are compoundable, as I said, under Section 320 CRPC. These around 50 offenses are of non-heinous nature. For rest of the offenses in IPC, we would like to know, and I believe that our esteemed guest today would share his wisdom and experience, whether for rest of them, and especially in heinous offenses, mediation may be applied in India as it is being applied in Western jurisdictions. And if yes, then in what form and in what manner, and for what purpose? With that, I request our esteemed speaker today, Shri Pradeep Rai ji, Senior Advocate, Supreme Court of India, and Vice President, Supreme Court Bar Association, to enlighten us on the topic. And after the address, we would have a short, brief session for question answer for our students. So over to Shri Pradeep Rai ji. Sir.
Thank you, Saurabh ji. Honorable Professor Mahavir Singh ji, Dean of the Law Center 2, Nitesh Saraswat ji, Saurabh Rana ji, the anchor of this program, Prashant Chandra ji, You see, it's really an honor to be part of any program which is organized by Law Center 2. As it was mentioned by Honorable Dean Sir, that there have been several luminaries, several guiding forces who have been students of this faculty. So actually, it's a matter of great privilege that I am here. And the subject itself is a matter of great pride, because now earlier it was ADR, Alternative Dispute Resolution. Then thereafter it was called Alternative Dispute Resolution. And formally now it is being called as Ultimate Dispute Resolution. So ultimate I say because when you actually both the parties, they start contesting a matter at the level of enmity, and there is no source between them who can actually go for the truth, then in those circumstances, this process is really important. Though mediation is not a new concept for India, but many of us, they follow this 40 hours and 5 days training programs, which is actually started by United States of America. In the first time when though believers are many, Mahatma Gandhi, Abraham Lincoln, there are so many believers. But I find the example of mediation in this Mahajanpat Kal. That was when this Kasi 600 BC, when this Kasi, Kosal, Ang, Magad, many other parts of India were actually ruled by the democratic states. One of them was Kusinara's Mal, then the Baisali's Lichwi, then even in Gandhar, which is now currently Afghanistan, we would not imagine that even there was democracy, and the disputes between the parties used to be settled by actually taking the opinion of panchas, and then primarily both the parties were given an opportunity to decide the dispute. If they do not settle it, thereafter the matter is brought before the panchas. That was the origin, I believe. However, today in modern age, we found it in Sher-Shah Suri's age. Sher-Shah Suri was an emperor who was originally from a small riyasat that is called Sasaram. From there, he captured the kingdom of Mughals kingdom after defeating Humayun in 1539. I think that was this after Chausa and Kannauj for 39 and 40. So these are the two wars. And when he captured, primarily he started having expert ministries in his department. So Raja Todarmal is a known name, who is actually the father of modern revenue laws. And when GT Road, which was constructed by Sher-Shah Suri, was being constructed, Todarmal suggested him that there should be a process which should not be arbitrary land acquisition. Because those days this road was being made from Calcutta to Peshawar, and they had this appropriate process in the acquisition where they started actually the aggrieved persons in the ministries, and they could have claimed the amount of the land, and finally the decision was obviously with the Maharaja and with the Sahansa, and that was the Todarmal decided the compensation. But the first example of compensation through a kind of mediation, that was not called mediation, but a kind of mediation, because the concerned person was given an opportunity to be heard, and he was being assisted by one of the Darbaris. And finally, Todarmal, who was the revenue minister, later he became the Ratna of Akbar, but he decided. In modern age, we found that Mahatma Gandhi, he started, our Rashtrapita, he started actually the concept of mediation. Recently, we have also organized several mediation trainings, because nowadays after this new mediation bill, you all will realize, and the students who are listening to me will realize that this is an essential part. Now the courts are going to refer the matters, especially civil matters, that if those matters cannot be settled without litigation, then only matters will be listed before the court. So some of the courts may actually adopt this measure, and if they adopt this, then there should be actually a shortage of trained mediators. So what I suggest for all of students, that you all should have mediation in the process, and it's really very nice on the part of Law Center 2 that they have selected this topic, Because normally the colleges, they do not select, they do not travel with the modern age. So traveling with the age, traveling with the time, traveling with the actually modern generation, current generation, and then the future generation of law, that itself is remarkable. I really admire Honorable Professor Mahabir Singh ji. I admire the faculty under Nitish Saraswat ji, Subodh Rana ji, Saurabh Rana ji, and Prashant Chandra ji. You see, it's not very easy to actually deal with such situation, and especially when there is no proper guideline, no proper syllabus. Even Bar Council is now issuing some actually directions, some kind of suggestions that mediation should be part of it. But this is really great. And nowadays I have seen that now even in moot court competitions, law center, especially our law center, Delhi University Law Center, they have started giving problems related to ADRs, not the international disputes, which our students, our actually the seekers of knowledge may not have the access of those matters. So just in place of giving a hypothetical problem, they have started giving something which is going to help you, which is going to give you an insight that how this ADR process is going to work. As far as this mediation of Supreme Court is concerned, originally, I think in the first matter was in 2003, when this was decided by this bar, V.S. Joshi and others matter and some other matters where it was decided that the court should actually adopt mediation, they should go for mediation process. And when they actually go for mediation process, then there should be proper opportunity to both the parties to settle it. And lawyers who are representing them, in place of them, if the aggrieved persons, the litigants, if they get an opportunity to talk, they decide, several matters gets resolved. This year around 2 lakh matters were referred to the mediation centers by NALSA, by MCPC, and I am pleased to inform that at least 1,13,000 matters were actually resolved by both the parties. Nowadays, NALSA is working under able leadership of Justice Uday Lalit. The Supreme Court Legal Services Authority is working under Justice Khanwilkar. And MCPC is working under Justice Sanjay Kishan Kaul. And the history, you were mentioning about the Delhi University Law Schools. I am pleased to refer that our next Chief Justice, thereafter another Chief Justice, and then the next Chief Justice, Justice Lalit, Justice Chandrachud, and Justice Khanna. All of them are the students of Delhi University. And the pleasure of alma mater is that when you actually get some of your student at the top of the institution, top of the judiciary, that gives immense pleasure. Now the subject is different. The subject is that not only mediation. Already referred by Sir, Saurabh Sir, that under 320 there are a scope of mediation and compoundable offenses and all. But when you start thinking about other disputes which were actually caused by the personal disputes between two parties, not by some criminal intent, like suppose when you are getting married, the purpose is very pious, the purpose is religious, you are following sapadi, or even you are doing all other actually religious rituals you are performing, and in any kind of religion, because all these things are necessary. The priest is there, and in the presence of God, you feel that you are getting married, and thereafter dispute arises. When these disputes arise, then the problem is that there is no end of it. It goes up to 376, 377, all kind of allegations. Even this case of case in Navasa in 2013, there was an allegation against this father-in-law by the daughter-in-law that he was forcing her to sleep with others and all kind of allegations. Ultimately, when this matter was referred to the mediation, and finally when this matter was actually heard and then dispute was settled, the court passes an order that the accused are discharged. So this was the case of 376, 377, all kind of allegations. I am simply on that point that when you actually face these kind of severe sections where you have to be in the prison, sometimes you lose government job, sometimes accused persons, they face a lot of mental agony, loss of respect, loss of face. In those cases also, the court found that yes, this case should have been actually discharged, that settlement under mediation and all. So they quashed the FIRs. And why they quash it? Because when there is a dispute between the two parties who have been the family, and because of the family dispute, series of litigations are filed, the courts decide that yes, these matters worth to given to rest, to meet the ends of justice. So that justice should not finish. There should not be any impediment in the way of justice. So many actually this history of this law commissions, like 41st Law Commission, then 129th Law Commission, they all actually raised this issue. They started, when this 41st Law Commission was, I think, this V.K. Sundaram. And then in chapter 24, they refer about the initiation of ADRs. In 129th Law Commission report, that was D.A. Desai. When they thought that there is a lot of congestion in courts, to finish the congestion, there should be some alternative dispute resolution system. It's not only arbitration, then mediation, conciliation, and all these things are there. But, and section 89, we should not forget that settlement of dispute outside of the court, all these things are mentioned. Then, despite all this, we have to realize that our courts in many districts are not referring matters to the mediation. At least we are lucky that in Delhi, whenever there is a matrimonial dispute or any dispute arises out of matrimonial relationship, they immediately refer it to mediation. And in between, till the process is on, they generally grant an stay or bail in those matters. I do not say that courts are always right. Like suppose there was a case in which mediation was private mediation, not by the district court referred mediation, that was between the village, panchayat and all. And finally, the two of the rapists who are from the neighboring village, they actually tried to get these issues resolved. And the lady who was the victim, she also compromised in those cases. And by those compromise, they filed the matter for the quashing of FIR. And the decision of the Supreme Court was that these kind of offenses cannot be settled. These kind of offenses should be dealt with its severity. The nature of the offense is so severe that you cannot settle this. So compounding and non-compounding also depends upon the courts. Like 482, under which the accused persons challenges the questioning of the proceeding, those proceedings they stand, and the court can quash any kind of proceeding because they are not bound by 320, they are not bound by 89 of CPC. Because High Court and Supreme Court under their own rights, they have inherent powers. Under 32, they can consider many things. 132, they can consider many things, including the High Court. When they consider any matter under 226 or 227, they have an extra authority by way of their inherent powers guaranteed or given by the Constitution, and they can quash any FIR by the nature of the offense, by the peculiarity of the offense, and they decide those matters. Like this MCPC, when it was started, MCPC was the Mediation and Conciliation Project Committee of the Supreme Court. It was originally conceptualized by Justice Ahmadi. And later, Honorable Justice Lahoti, who was a puisne judge who came from the Delhi High Court without being a Chief Justice of any High Court, he was brought here in Supreme Court by bypassing Justice Sabharwal, who was then Chief Justice of Delhi High Court. He did a lot of reforms. In MCPC, there was no space, there was no mediation room, there was not even an office, there was no budget. But they started actually rolling the balls. And by that, they decided that several matters should be, even if they are fall in the category of, not in the category of 320, even those matters should be given proper justice, because the person who is suffering because of such allegations, they require justice. And not only they, but even if the other complainant, by leveling accusation, by leveling just because of the relationship is not good, just because they have left the house, just because they are contesting cases or a series of litigations in various courts, even domestic violence act, sometimes in this unnatural sex, sometimes rape, sometimes all kind of dowry. So 498A, irrespective of 498A, they have actually uphold from various high courts, even in Supreme Court, depending upon the nature of the case, they have decided that such matters can be actually granted relief and such matters can be settled. Because the parties of the offense, like suppose you are an officer in the prison. If you are an officer in the prison and you commit something of which an allegation of non-compoundable offense is leveled against you and FIR is registered and you settle that matter, that settlement is not valid. Because serving government servant, serving as a public servant, then you breach the trust and thereafter you do something that cannot be settled at all. I recall few examples like 2G cases. That is the best example. 2G cases, when actually the 2G licenses were granted, there were several MOUs signed by the different telecom companies and the government and some of the other partners who were actually from the abroad. They had special arbitration clauses. They had special mediation clauses if there is any dispute. But because this was treated as a scam, so all these clauses go. The court did not consider certain things because this matter fell in the purview of PC Act after the CBI investigation. When this matter falls in the PC Act, then your original agreement, whatever it may be, just to cover up your offenses of corruption, you cannot take the shelter of mediation or arbitration. Your granting your license was in civil nature. Your deposition of fee was in civil nature. Your operation was a business activity. Despite that, the method, the way you got the license, that fell under the PC Act, and that was the reason court did not grant anyone any relief and matter was referred to CBI. Justice Singhvi, Honorable Justice Singhvi, before whom this matter was being heard, originally all these arguments they tried to level that India will lose the face because several other government companies of abroad, like Norway's company, Telenor, were the partner of Unitech. And they formed a company called Uninor. So all these arguments were rejected by the court. So in place of, even if there are provisions in the agreement, even if there are provisions under the law, the public interest, the interest of society at large has to be considered. Unless you consider that, you cannot arrive on a proper justice. I have personally seen several examples where Honorable High Court has not only granted bail, but they have caused several cases where this non-compoundable offenses were there. Even it was upheld up to the Supreme Court. But again, the opinion of the court differs on the basis of case. So case to case basis, there are different opinions. And that opinion has nothing to do with the rights of the trial court and the rule framed by the acts, especially for the district courts and trial courts. Because under 482, under 32, under 226, 227, 132, Supreme Court and High Courts are not bound by those exemptions, those limitations, those categories in which the compounded offenses should be given to the mediation or given to the arbitration. There have been several occasions when High Court is considering some matter, but in between Supreme Court intervened and they have taken the matter. They can transfer the investigation. They can do many things. They can do anything in order to do complete justice. That is the strength of our judiciary. Like in UK, if you go there, you will find that UK Supreme Court can give an opinion. They can express an opinion against the act. They can express an opinion against the decision taken by the government because of existence of that act. But they cannot set aside the decision taken by the government based on that act because their powers are limited. Our court has extreme power. They can declare anything ultra vires. They can declare an act unconstitutional. Like in NJSC case, they have done so. Like in US, you will find that US high courts, and that is called circuit courts, they have also huge powers. I recall a case where the President Trump was holding a press conference and he was being asked several questions by a particular journalist. He said that I will not answer your questions and I don't want to see you, and White House issued an order banning that journalist. But what was the outcome? The journalist challenged the White House directions before the circuit court, and circuit court hold that the office of President of United States is the workplace of that journalist. And if that is the workplace, you can't restrain him. You can't create any kind of impediment in the way of discharging his duties as a journalist. And from next day, he was in the office of President of India, President of United States, and every day he was covering and reporting against him. So such things are there, but our constitution, our court's power are different. In my opinion, our courts can do anything. Our court can pass any order which is actually required for the protection of fundamental rights, or which is required to protect the justice, which is required to in order to do complete justice. They can do anything. They can pass any order. And that is the reason we have developed a tendency while filing the petitions that in one or two, three prayers what we want. But the last prayer is always there, that as court deem fit. As court deem fit means though these prayers are now in practice being filed in district courts also, but district courts have restrictions. They can't go against the authorities. The authority judgments given by the high courts, given by the Supreme Court, they can't go against that. If a judge is doing so, he deserves action. He deserves disciplinary proceedings against him. But the High Court, Supreme Court, they have this kind of power. They have derived this authority by our constitution. I will refer the B.S. Joshi case. That was I think 2003 4 SCC. It was again the 482 was the power of the 482 of the high courts. They decided that they can do anything. Even in Gyan Singh versus State of Punjab, that is SCC 303 2012 case. Again, they said that even the disputes which are by holding these cases, Doshi cases, and they said that the offenses which are severe in nature, they cannot they cannot settle this. So all kind of opinions are expressed by the courts. I have list of several judgments which can be shared by me to you, because those things are irrelevant, because you all understand this, and being the student of law, you all know that these judgments, the court has diverse opinions in different cases. So in my opinion, you all actually deserve to have a system in which the courts has absolute power to deliver justice, to decide a matter, in which they can go beyond the compoundable offenses, non-compoundable offenses. They can go beyond 89 CPC, they can go beyond 320. And they actually, when this Legal Services Act is there, 1905, they are also, they promote it. But nowadays, it is a kind of practice where in matrimonial cases, I have seen that mostly courts decide something which is actually completely not in the purview of 320. So all these things are happening. If there are any questions, you all are welcome to ask, so that we can finish the program on time. And Saurabh sir is there. I think he has already taken a glass of water, so he is ready for this class. Thank you, sir.
Thank you, Pradeep sir. Now I would request our students to ask any question if they want to. Yes, Rishabh.
Good evening to everybody.
Good evening. Good evening.
Sir, I want to ask that what kind of arguments can be presented while invoking the section 482 of CRPC to compound the offences which are not covered under section 320 until some statute for mediation of criminal offences come into picture?
Yes. So, Rishabh, you see, when I answered this question while speaking only, because when you are actually filing a 482 petition on the basis of compromise, and that is the compromise between the two parties, in which it is evident that these matters, these offenses, or these allegations are leveled against them because of the family dispute. The nature of dispute is very important. I said that if it is a government servant and he has done something wrong, and then this matter is brought by the way of settlement, it can't be settled. The courts are very clear. But suppose your wife is leveling allegation against you, any kind of allegation against your father, against your sisters, against your unmarried sisters, or somebody who is already married and settled abroad for the mental harassment in the DB Act. So in those cases, when there is a compromise, or even without compromise also court can do something, but when there is a compromise, when these matters are brought before the mediation, mediator can't submit all the reports. Mediator can settle only few disputes, which is under 320. But his report matters sometimes for the opinion of the court. And then courts decide it. Are you clear, Rishabh?
Yes, sir. Thank you so much.
Thank you, Rishabh. Yes, Utkarsh, you can ask.
Good evening, sir.
Yes, yes. Good evening. Good evening.
Sir, I wanted to ask you a question, sir. In 2009, by a way of amendment, we have actually made section 354 of IPC non-compoundable. So, sir, the trend has to be in the favor of making more penal offenses compoundable, but this has been going in the reverse direction. So, sir, what do you think is the right way to approach this?
Again, I say that whatever the amendments are there, whatever sections are there, but your High Court and Supreme Court, they are completely authorized, empowered, they have authority by the Constitution to decide any matter. And any matter on merits, they can decide on its own merits, irrespective of the Act, irrespective of the court, irrespective of the rules. So whenever you raise an issue before the High Court or before the Supreme Court, they are not only bound by these provisions. These provisions are there to restrict the district courts, because sometimes you find several complaints against district judges. Even now, whenever you see that there is a judge being recommended for a justice in the High Court, you will find several complaints against him. The time his name is being recommended, you will find that it is flooded with complaints. Not only to the Supreme Court, not only to the High Court, but even to the government, so that his name can be blocked, his or her name. So this happens, but the High Courts and Supreme Courts, they have absolute power. They can decide any matter in order to do complete justice. So they decide compoundable, non-compoundable, whatever it is, they can pass any order. And they are passing it. They are exercising these rights. They are exercising these powers.
Thank you, sir.
Even, sir, I want to add something to it.
Yes, yes.
Even in B.S. Joshi case, the Supreme Court said that we are not compounding the case. We are quashing it under Section 482. So it depends upon the merits of the case. They would quash the case.
Yes, yes.
Yes. Yes, ma'am. Kiran, madam.
Good evening to all of you.
Good evening.
Distinguished speaker, I just want to know that you have referred to 498A cases also.
Yes,
as far as 498A cases are concerned, they are of course matrimonial offences.
Yes, ma'am.
And the section itself fall in offences against marriage. What I want to know is that if an FIR is registered,
yes, ma'am,
it's true that there has to be mediation and all that. Everything has to be done. And suppose the parties come to a compromise, and generally they do come to a compromise.
Yes.
Even after that, the family court has no power to quash that FIR. For quashing the FIR, parties have to apply to the High Court.
Yes,
why can't this offense be made non-compoundable? Presently, it is cognizable, non-bailable, and non-compoundable.
Yes,
why can't it be made compoundable? Why the parties have to go to the High Court? You know,
yes, ma'am, that is the wisdom of legislative. That is the wisdom of legislative. So that issue has to be decided by the legislative, but as per the existing and prevailing rules and the sections, always 482 is there. 482 is for the questioning only. Even if it is not in the category of compoundable, they decide. But you are right, at least in the matrimonial cases, that is my personal opinion. I agree with you, but that our personal opinions doesn't matter unless legislative intent and legislative provisions are there. They have to they have to come forward and enact it. Nowadays, we do not see even in Parliament any discussion, because if you don't discuss
even though there is a recommendation from the Law Commission of India.
Yes, ma'am. Yes, ma'am. That is there.
But made compoundable offense.
Yes,
why should the party come to the High Court? High Court is there one in each state, and states are so big in India.
No, I follow that. But the only problem is that our parliamentarians, they have to take a call. They have to decide these issues. They have to actually debate, and thereafter their intent should be clear. Like we have seen a 6th schedule, that in 6th schedule cases also, you see when you start adding some this tribal status and all, how they go about it. Because then they immediately go to intent. The ultimate decision, legislative intent. Once you bring a law without a legislative intent, without discussion, there are several other things which are undecided. Even judges are not clear. So the superior courts, by passing the orders and by deciding, by ruling, then ultimately a law is there. But I agree with you that this power should be given to the district court, and even not only district court, why not to the mediation? If the nature of dispute is private, it's a family dispute, then 100% all these issues can be settled by way of mediation. And it should be given, and it will happen. You take it from me that the days are not far when the mediation will be actually a very prominent source. And lawyers will also be decided. They will be judged by their ability, that how they are avoiding the litigation, not by their ability to win the litigation, because then that will take years. So all these things are in the pipeline, but it will happen. 100% it will happen, and we should be hopeful, and we should pray that the wisdom prevails, and our parliamentarians and our this law ministry, they accept the advice, they accept the reports, recommendations of law commissions.
Yeah, but so far they have not accepted on this aspect.
Yes, you are,
Maybe the
yes,
reason,
yes.
even the National Women Commission has started a move that they are organizing conferences in all parts of India, like Northeast, East, etc., all over India. And they are seeking the opinion, local opinion, whether it should be made compoundable or non-compoundable.
In
Unfortunately,
Northeast, ma'am, this
these,
problem is not there.
these
In Northeast,
feminists,
this problem is not there.
it is there. It is very much there.
No, because
In
they fall,
Northeast,
Northeast, they fall in the sixth schedule, and there are district councils. Like
Yeah.
member district council have all the powers, and they rule. Sometimes in rape cases, they even Arunachal, I have seen that in tribal courts like district councils, they pass an order. Nowadays, these local courts are there, and I am also one of the person who was instrumental in establishing the local judiciary in the Northeast. But mostly, when there are dispute between the two tribes, it goes to the district council. When it is a tribe versus an outsider, means the non-tribe, it goes to the again district council. When it is completely between the two non-tribals, then only district courts, then district court decide these matters. So I have seen that. I am aware of all these. But ultimately, whatever the Women Commission do, they should write the recommendation. Being the member of your Women Commission chairman is member of National Human Rights Commission.
Unfortunately, the outcome of these conferences and these discussion is that everybody, the women organizations, they were very much against making it compoundable.
Yeah, that happens, but I am not on that today. I am just my scope is very limited, ma'am. My scope is whether the court can actually go beyond the 320 or not. So my only submission was that High Court and Supreme Court can go, but not the district courts. And whatever suggestions you are giving, will be thankful if Law Center 2 compiles this and all this discussion, and they compile a report and write it. Even after your concern, if you are willing to write it to me in my official capacity as Vice President of Supreme Court Bar Association, even I can write. Even I can write that these are the suggestions given to me, and I feel these suggestions worth considering. So I can write that. But ultimately, decision has to be taken by the Parliament. They should not cut short the Parliament sessions. They should actually make some good laws which is going to serve the country. And actually, all these matters depends upon case-to-case basis. It's not that there will be universal rule to decide. Actually, the mens rea has to be looked into.
Yeah. Thank you.
Thank you, ma'am. Thank you, Kiran, ma'am. Thank you.
Vishal Garg ji, want to ask a question?
Yes, sir. Good
Please
evening,
go
sir.
ahead.
Good evening, Vishal ji.
Sir, I have a question that suppose husband is living in Delhi and wife is suppose living in Rajasthan.
Yes.
And both husband and wife have filed non-compoundable cases against each other.
I think your friends are harassing you. You have to go a little bit far so that I can listen your voice only.
Yes, sir. Am I audible?
You are audible, but some other voices are also coming in.
Oh, so I'm repeating my question.
Yes.
Sir, like husband is in Delhi and wife is in Rajasthan. And both husband and wife have filed some non-compoundable cases against each other in Delhi and Rajasthan.
Yes.
So now suppose compromise happens between both husband and wife, and husband says that let us file a petition under 482 CRPC in Delhi so that the cases against the husband are quashed.
Yes.
Now suppose this quashing happens in Delhi cases, and now when it comes to Rajasthan cases, later on wife denies for coming for under 482 CRPC. So in such a case, my first question is that can that quashing order which has been filed by Delhi High Court be challenged? And another question is that should the husband and wife both should have gone to Supreme Court for mediation in such case?
You see, Supreme Court mediation is one option, is always there. But in these cases, when husband and wife just settle the issue, normally what happens if husband is complainant in Delhi and wife is complainant in Rajasthan, she will get the case transferred from Delhi to Rajasthan. She will file a transfer petition, she will get the case transferred there. And then the settlement has to happen there only. If it doesn't happen, Husband can pray that the case may be transferred. Even if both the situations are not there, even in Delhi High Court, while making a statement or arriving on a compromise, Delhi High Court will consider all those facts and they will record the statements given by the wife, which is on the affidavit. So on the basis of, even if she is not withdrawing it, on the basis of, you see, 482 can be exercised not by, it can be decided only on the facts. And the facts are that allegations are frivolous, worth quashing it. It is not in the compoundable or non-compoundable category. It may be non-compoundable, it may be compoundable. But when you file 482, court has to consider that matter on merits. And if they have considered by recording the statements of husband and wife as their compromise, they cannot actually retract their statement. It will go to the High Court, other High Court will consider it. So there is very lesser possibility, unless there is some undue influence or whatever that I don't want to mention, that is there. But again, the Supreme Court will consider it.
So, sir, my question is that, like, if such a situation can happen, or if there is a doubt between husband and wife that if later on wife or husband can deny for quashing, so should they have already approached to Supreme Court in the first instance only?
So I told you in the beginning only that the cases normally they file transfer petition.
Okay.
And they pray that the matter may be transferred to the Supreme Court because it is involves two states, or both the matters will go to the one state, or matter will be taken to the Supreme Court.
Okay.
So normally, the wives, they file transfer petition, they get a relief, matter is transferred to the state or place where wife resides. And then the settlement is applicable in both the situation.
All right. Thank you, sir.
Thank you.
Sir, I have one small question here.
Yes, sir.
You allow me to ask?
100%, sir.
Sir, how do you see future of mediation in heinous offences, like in those cases which are not covered under Section 320 CRPC? Do you see institutionalization of mediation for those offences which are not covered in Section 320 CRPC?
Sir, normally
Can
the
we have
criminal
kind of
offenses,
compulsory mediation for them also? I mean, the way we have, we
Yes,
are
sir,
going
yes.
in that direction in civil cases. Do we have in near future that kind of a mechanism where in every case, even those cases which are not covered under Section 320, we would have a compulsory mediation kind of an idea applying to criminal cases also, or at
Sir,
least
now-
or at least some initiation come from judiciary.
I just want to add one point more. Can
Yes,
we
ma'am.
go for plea bargaining also? Through
Pre-bargain
mediation.
is there, ma'am. Pre-bargain is there, but pre-bargain,
there.
the mediators are not judges. Even if when
Yeah.
you are acting as a mediator, you are no more a judge.
Yeah.
Right.
So that jurisdiction goes. Plea bargain has to be before the court only,
Yeah.
in the court only. So it can't be done by the mediator. However, the mediation of criminal matters or the heinous offences that this Saurabh sir is mentioning, I will say, sir, that these offences, I don't think that it will be allowed in near future. I don't see any possibility. But they will extend the ambit of family disputes, like all these heinous offences, especially when it's not offences, but actually it was because of the family dispute, because of the business dispute. Those matters can be brought to the ambit of mediation. And
I mean,
anyway,
the roots of dispute which are there in civil cases or matrimonial cases, they may be taken to mediation even in criminal.
they will be taken. They will be taken in near future and very soon. I am not saying that it will take time. Because you see, now we don't have so many mediators. There are not even mediation training. I am thankful to Honorable Justice Ramanna, Justice Sanjay Kishan Kaul, and Justice Lalit that at least they started mediation process. They started mediation training. Till date, Supreme Court of India has only 34 mediators. Now, because of me, we have organized several training programs. So now we have around 250 more. So by adding these 39 and 250, It's less than 300, sir. Less than 300 mediators in the entire Supreme Court since the inception of MCPC. So it's not a very welcome tradition. I say that at least even if somebody is not, and then it is the training is given only those lawyers who have completed 10 years. Why not to the young lawyers? Why not to teach them? Like we have seen in the syllabus.
Why not
and
to
the
the
course.
teachers also? Why not to the teachers also?
Teachers option is there, ma'am. If you all want, I welcome you all. I can invite you. I can give you this certificate of MCPC also. You can attend 5-day session. That's there.
Okay.
If you all
Definitely,
want,
I will
you
approach
should be in
you
touch
for that.
with me. You should be in touch with me.
I will be in touch with you.
Yes. So, and anyway, my website, my this LinkedIn page, even an Insta page. Not only this, even in Supreme Court Bar website, everything is there. Anybody can write something, and we try to address that. Even for interns, I am providing these options that you all can apply on the Supreme Court Bar website. From there, you can get the opportunities of internship.
Sir,
Because
for fresh law graduates, are there any career opportunities for
Yes, sir. Yes,
as
sir.
mediators?
Yes, sir. That's what I was mentioning. That you have to apply on that website and 100% be circulated among the members of the bar. And if somebody is suitable and if they come by your recommendation and you find them suitable, 100% we accommodate, because we all lawyers, we try to get good juniors. It's not that every lawyer has good juniors. Sometimes junior have to work hard, they have to learn, and we welcome if the law center too takes steps in this direction. I really welcome it, sir, that your concern.
Thank you, sir. Thank you.
And next time, 100% in our training program, Kiran ma'am is there. So
Thank you. And we will
Yes,
send
Kiran
our
ma'am.
students also for training.
Students, ma'am, I don't know, because students, what they have done, that students, we are trying to get it relaxed from the 10 years to 5 years. The
Okay,
mandatory
okay.
condition is that you should be law graduate for a period of 10 years.
Okay.
And today, any lawyer who is of less than 10 years, they can't do it, even if they want. But my suggestion is that why not to get them trained? You don't declare them mediator, but at least let them have the training. And
But then,
if
sir,
there is a steep
but,
law
sir,
center, yes, sir.
I would interrupt here. When we are making freshers judicial magistrates, when we are making freshers public prosecutors, so why not mediators?
But sir, those magistrates don't get training unless they complete 10 years. That is the issue.
No, but they
That
are
is the
manning the
problem.
courts. The magistrates are manning the trial courts. Even they.
Yes, they feel that there are several training programs, extensive training programs at Delhi Judicial Academy. You will surprised to know, sir, that for the first time, any judicial academy was open for the members of the bar. They have huge infrastructure all over the country, but they don't allow teachers, they don't allow students, they don't allow lawyers to get the training there, even if it is vacant. In a month, there will be 1 or 2 training, that's all. Why not utilize from Monday to Friday also?
So mediation
judges can do
training is
training.
restricted. Mediation training is only with the judicial academies.
No. It is there, but it has to be recognized. Na? That is
Yes.
the problem. So
Okay.
first time we did it from the MCPC, like Delhi High Court does, and then district courts also organize it. But the problem is that they did not open judicial academies so far for any of these institutions. Our training was the first time, because I persuaded honorable judges, I persuaded everywhere, and I know what all I had to do. Then only they opened the academy, and finally the lawyers got the training. I said, in Saturday, Sunday, if you are training the judges, give us other 5 days.
Right, sir.
Whoever is interested, they will leave the classes, they will leave the course, and they will come. And it happens. And I am
Let me
really
tell you,
grateful to.
in Delhi Judicial Academy, they are having programs for training to counselors, especially the family court counselors, along with family court judges. And
Ma'am,
we
I did not
people are
listen. I'm
used to
sorry.
call it- In certain judicial academies, like Delhi Judicial Academy,
Yes.
they do organize training program for counselors and family law judges, and they used to call us as resource persons.
Yes. They are nice,
are
but again, but it was never open for any student, never open for any faculty for the training. it was never open for any lawyers. So
Yeah.
at least I don't know that any student, any faculty member, or any lawyer, they have attended any training program other than this, which one I was organized by us. This was the first time when we did so.
Nitesh sir want to say something. Nitesh ji.
Yes, Nitesh ji, please go
Good
ahead.
evening, sir. One question from my side also. Actually, the confusion comes in my mind when I think about the socio-economic offenses related to the escaping of the taxes, where there is a severe penalty or where there is also, you can say, arrest and all these things. So white collar crimes, socio-economic offenses, what can be the scope of mediation in these areas?
White collar crime, war against the nation, it can't be mediated, sir. NDPS.
But most of the cases related to the taxation are settled through the government machinery only. And
So there is a different process for settling them. They don't require mediator.
Yes, I think Kiran ma'am is there to help me out.
As far as white collar crimes are concerned, there should not be any mediation. If it is proved, they should be punished. But in tax cases, they have their own procedure of settling.
that is the confusion I am asking.
That is called settlement. That is called settlement. Like even this bank, they declare NPA, again there is a settlement on loan. That cannot be decided by the courts, by the mediators, because it requires expertise of a specific area. And they are the right person. Suppose I give you a key of helicopter, will you take and fly it? You will never fly it because you don't have license, you don't know how to fly. So it's better what we don't know, though judges, some of the judges, they feel that they can do anything, but it's not the reality. Everybody should not cross the line of which they have been assigned, they have been empowered, they have been authorized. So everyone is like that only. Like a teacher who is teaching you, he can't take admission in the other class. You are attending the class, you can't become the examiner. So there are so many restrictions. It is a normal wisdom, very common wisdom, and that you all know, sir, very well, and you have extremely competent faculty. They are able to teach you, guide you there.
And sir, one more thing I would like to add here.
Saurabh sir, last question, because I have some guests at my.
No, I just want to add something to it, as you are saying, because
yes, sir.
Mediation happens between two specific persons.
Yes.
Now, in such cases, so they are usually like one is the accused side and the other is the victim side. Yes. But here, as Nitesh sir was saying, in such cases, there is no state is no specific person.
Yeah.
And victim is not the state, but victim is public.
Yes.
Yeah.
That's why we do not encourage mediation in such cases. As rightly you said that it is kind of a settlement between state and the tax evasion. That is not mediation.
Yes.
I was finding the scope when you asked the question regarding the heinous crimes, actually.
No, sir, you are right. Daksha, you are actually right. We were just making fun of you so that to make the program light. It should not be too heavy. You are right at some extent, and we're looking forward to meeting you all physically. I don't enjoy virtual sessions.
Right.
But
definitely we will call you.
Definitely, sir, we will call you.
Give you the trouble to come to our institute.
Attending your
you are
program,
most welcome, sir.
not having even a cup of coffee with Kiran ma'am is not a good idea.
Right. Now I would request Prashant ji to present vote of thanks. Prashant Chandra ji.
Thanks a lot, sir. Thanks, Pradeep Rai, sir, for giving us your precious time. Sir, I would like to first of all thank Professor Kiran Gupta ma'am, Professor Mahavir, sir, PIC of LC2, Professor sir, and Professor Pinky Sharma ma'am, and also my colleagues Saurabh Rana sir and Dr. Nitesh Saraswat sir for helping me arrange this lecture with sir. First of all, sir, I would like to inform you that initially when I was told that I have to arrange a speaker for mediation, your name straight away came into my mind because I have seen it in the Supreme Court that you have made life to this Mediation and Conciliation Project Committee of Supreme Court. I have seen that you have given it a great life after you joined as Supreme Court Vice President of Supreme Court Bar Association. Previously, I could never see any kind of mediation programs, but in the last 3-4 months, I've seen that you have this own programs, even for women was a separate program which was going on Jubilee mediation. And sir, it was a great, you started with the ancient times, the video, how it started in the ancient times, then Gandhi and sharing experience reported how people misuse 482 by filing cross complaints and bringing 376, 377 in personal insights. This might have, I am sure that this might have helped the students a lot in today's discussion. And there were also a few questions which were primarily raised by our faculty members. So all of us, and with personally, to meet you personally in the faculty and have some lecture in auditorium something in the future. You are available and we can arrange another lecture or any other topic. It was a great time, sir.
Thank you, sir. Thank you so
Pradeep,
much.
sir.
Saurabh,
Thank you,
Thank
Pradeep,
you, Saurabh,
sir.
sir. Thank you, Kiran ma'am. Thank you, Dean
We
sir.
hope to see you soon in the
Thank
faculty.
you.
And we would invite
We
you
will
to the
definitely
faculty.
meet.
Thank you, Prashantji, for giving me this opportunity. I am really grateful to you that I had a...
and sir, thank you for taking out time for us.
No, thank you so much, sir. For I like any program where students are there. I never say no to that. Thank you so much, sir.
Right, sir.
Thank you, sir.
Thank you, sir. Thank you so much, sir. Thank you, sir.
Thank
Thank you.